The penalties for a DUI conviction in Georgia are based on the number of DUIs you have in the last 10 years and in your lifetime. So the statute has certain mandatory minimum punishments for DUIs within the last 10 years. For a first DUI in 10 years, there's a minimum mandatory 24 hours in jail, a maximum of a year in jail. The fines can range anywhere from $600 to $2,000. That's including court cost. There's 40 hours of community service that's required. You have to attend and complete a 20-hour DUI risk reduction course, or commonly referred to as DUI school. You have to report to probation for 12 months. And there is a probation supervision fee of approximately $50 a month. Now, that's what's required by statute. Typically, prosecutors and judges will also require that you attend and complete a drug and alcohol evaluation from a licensed counselor or psychologist, that you attend and complete a victim impact panel, which is a 2-hour program where you listen to essentially stories from people whose lives have been negatively impacted by DUI charges. And the final thing is, oftentimes while you're on probation, you'll be prohibited from drinking alcohol or using illegal drugs, and you'll be subject to random screens of your blood, breath, or urine. The urine tests they have for alcohol now are called ETG tests, and they can detect alcohol metabolites, or the byproducts of alcohol, once it's broken down in your body up to 80 hours after you drink. So it's very difficult to drink on probation without getting caught because of that 80-hour window. Now, that's for a first DUI. That's not bad enough. A second DUI in 10 years, you're subject to a minimum mandatory 72 hours in jail, a maximum of a year in jail. The fines essentially double. So the minimum fine is $1,200. The maximum fine is $2,000. There's 240 hours of community service, or 30 days of community service. You have to complete 12 months of probation. You have to attend and complete the DUI school. You also have to obtain a state-approved drug and alcohol evaluation. You're subject to having your picture in the newspaper, and they can confiscate any license plates for vehicles registered in your name. On a first DUI, the license suspension is 120 days for a DUI conviction for first and 10. For a second and 10, the DUI suspension is 18 months. But you can get your license back after 4 months with an interlock device if you drive on that interlock device for 8 months. And then the remainder of that period will be what's called a limited permit, where you can drive only to school, work, doctor, DUI, counseling, dependent children and dependent parents in Georgia only. On a second and 10 DUI, you can obtain sometimes a limited permit, interlock limited permit, prior to the 4-month period if you get an order signed by a judge allowing you to get your license sooner. That requires you be in some sort of rehabilitation program or a DUI court program. Now, for a third DUI in 10 years, there's a mandatory minimum 15 days in jail, and the maximum period of incarceration is 1 year in jail. Again, the minimum mandatory fines are $600 or $1,200 for a third DUI, and $2,000 is the maximum fine. It's considered a high and aggravated misdemeanor, which means that you don't necessarily get the same type of good time credit in jail that you would get for a regular criminal charge. A regular criminal charge, you get 2-for-1 credit typically if you behave and it's being offered by the jail. For a high and aggravated misdemeanor, you get 4 days a month. So you can do a significantly more jail time for a high and aggravated misdemeanor. Again, you have the same issues with the 240 hours of community service. You have to obtain the state-approved drug and alcohol evaluation and any required treatment. You're subject to the tag confiscation and the picture in the newspaper. And that's pretty much what's required for a third DUI in 10 years. For a fourth DUI in 10 years, it's considered a felony, and it's all the same penalties and conditions of a third DUI in 10 years plus 1 to 5 years in state prison. Now, the only other potential penalty for a DUI, and it doesn't matter whether this is a first, second, or third, or fourth, is if you refuse chemical testing, you're issued a DDS form 1205, and you either don't request a hearing or you request a hearing and the refusal suspension is upheld, where they only have to prove that there was reasonable grounds to arrest you for DUI and that you refused, then you lose your license for a year, regardless of whether it's a first, second, third, or fourth DUI in 10 years. Now, for multiple DUIs outside of 10 years, but in the lifetime, there's no mandatory minimum punishment, but it's very common for judges and prosecutors to recommend punishments that mimic the mandatory minimum for the first, second, and third in 10 years. So if you have a third lifetime DUI, you might be recommended for DUI court. You might be required to do 240 hours of community service, et cetera. You might be required to get a drug and alcohol evaluation by the court or prosecutor and their either sentence or guilty plea offers, just based on even though there's no mandatory minimum sentence, based on the number of DUIs that you've had in your lifetime.